Hello all, and good morning or good afternoon to wherever you are joining us from today. My name is Daniel Johnson, and I am the Director of Marketing and Customer Experience here at My HR Council. And I'd like to thank all those for taking the time to join us on today's webinar. And I would especially like to thank those that continue to join us each month and to all of our first-time attendees. We greatly appreciate your interest in our monthly webinars, and we enjoy hosting them for you. Now, before we get started, there's just a few housekeeping items I'd like to address. The first and foremost, we always record our webinars. You can look for it on our YouTube channel. Otherwise, we also send out an email every Thursday following the webinar that will have the webinar recording, the slide deck, as well as the HRCI credit to those who are seeking those HRCI credit codes for certification. And if you have to drop off, we will have that webinar for you, and you can reference it at a later date. Throughout the presentation, if you have any questions, feel free to use the chat feature on the control panel. Otherwise, you can email us at info@myhrcouncil.com. If you're a client of ours, feel free to reach us at any time through our Ask an Attorney portal, where we can give you that legally backed guidance for your question. And now I'd like to pass it on to Britt Waterman, who is a senior attorney here at My HR Council. Thank you, Britt.
Hi, thank you. Thank you. Welcome everybody for joining us today for our third Tuesday webinar. Today the topic is going to be COVID and the ADA, the intersection between employee protections and employer rights. This is a topic that has started at the very beginning of the pandemic and has been evolving and going on up till now, and kind of going back and forth with vaccines, and then with the Delta variant, and with masking, and so it's kind of gone back and forth. So we're going to discuss some information that may be kind of some review information, or something that was new information at the beginning of the pandemic, and how that's evolved now, all the way up to vaccines, and how the ADA intersects with vaccine policies, asking for proof of vaccines, and those kinds of things. And then just a follow-up on masks, as we for a while we're thinking that masks were maybe something we weren't going to have to worry about so much anymore, and now that is kind of starting to change. So we'll cover all those topics, and hopefully answer questions that you've been thinking about, and questions that you've never thought of before, but that will maybe change the way you're doing things, or give you something to think about. Like Dan said, I am a senior attorney at My HR Council. As I said, just kind of the agenda is give you kind of a history and overview of the ADA, talk about COVID as a disability, and those high risk conditions. Talk about confidential medical information. What is confidential medical information? What do we do with it? And then I said get a little bit into vaccines and the ADA. And I believe in the follow-up email, we also will be sending a survey that you can complete and let us know what topics you would like to see on the horizon coming up for the rest of this quarter. And then beginning in 2022, we will just let everyone know we will be announcing a date and a time for a webinar on the OSHA rule relating to President Biden's executive order for the vaccine mandate, as soon as the OSHA rule is announced. So right now, that's not something I can talk about. We don't have information. The OSHA rule has not been issued, so we don't have questions about a federal vaccine mandate and what that's going to look like. But as soon as that information is released, we will be putting together a webinar on that information, and registration for that will be, a time and a date will be announced, and registration will be made available immediately. So please keep an eye on our emails, our newsletter, things that we send out, and you will know as soon as we have that information. So just flashing back to what is the Americans with Disabilities Act and Amendments Act. So there's the ADA, and then in 2008, they added the amendments, so it's technically the ADAAA. The ADA defines the criteria for whether a disability exists and how to provide reasonable accommodation in the workplace, in housing, in places of public accommodation. We are focusing obviously on providing reasonable accommodation in the workplace. The ADA regulates medical examinations and when and how medical examinations can be performed by employers. Disability-related inquiries, what can you ask someone, when can you ask it, how can you ask it, and then confidential medical information, what is considered confidential medical information, what do you need to do with that information, can you share it? That is all regulated under the ADA. So the current definition of disability, physical or mental impairment. So that can be any psychological disorder or condition, any cosmetic disfigurement, any anatomical loss, anything that affects the neurological, musculoskeletal, special sense organs, respiratory, speech organs, cardiovascular, reproductive, digestive, genitourinary, hemic and lymphatic, skin and endocrine system. Also any mental or psychological disorder, such as an intellectual disability, organic brain syndrome, emotional or mental illness, and learning disabilities. That covers a lot. So if if you're wondering, this person has an emotional condition or a physical condition, it probably falls under that umbrella, and that definition of physical and mental impairments was expanded widely in 2008. So to have a disability, you have to have a physical or mental impairment. It has to substantially limit your ability to perform a major life activity as compared with the general population. So to substantially limit the ability to perform the major life activity means that the ability to perform the activity must be significantly restricted. And again, as compared with the general population, just because someone can't do something that an individual with particular strength or ability wouldn't be able to do, that's not necessarily a disability. We're comparing you with the general population, someone who may not have a particular specialized skill or ability. Major life activity, any interference with the bodily systems or organs, reading, learning, working, communicating, concentrating, thinking, caring for oneself, but also any function of the neurological, reproductive, digestive, respiratory, circulatory system. So any function of any bodily systems. So something like, infertility. Is infertility a disability? It substantially limits or significantly restricts the function of the reproductive system. Is it a physical impairment? If it is caused by a physical condition, it certainly could be. So something like that could fall under the umbrella of disability. That would be something that maybe we wouldn't necessarily think about. Mitigating factors, I think we all know, cannot be considered. We can't tell someone you don't have a mobility disability because you're in a wheelchair and your wheelchair can move you around. Episodic impairments in remission, still considered a disability. Is COVID a disability? COVID can certainly be a physical impairment. A function of the respiratory system, as we just described, is a major life activity. The question becomes, is this major life activity, the function of the respiratory system, or other functions that may be affected by COVID, sleeping, breathing, eating, mobility. COVID can have any number of symptoms, sensory activity. Is this major life activity significantly restricted with a mild to moderate case of COVID? So temporary conditions or short-term illnesses generally don't qualify as disabilities under the ADA. Things like colds, flu, sprains, somebody sprains their wrist or their ankle, that's not going to be a disability. Even something like a mild concussion that goes away in a couple of days isn't going to be a disability. Things like that are too temporary to substantially limit someone in their ability to perform life activities. A short-term illness that has long-term complications can qualify as a disability. So when we talk about long COVID, that can certainly qualify as a disability. Conditions that result in flare-ups or only temporary periods of restriction can be disabilities. If someone has some type of organ damage with COVID that later shows up, that could be a disability. A severe case of COVID that results in several weeks of hospitalization. When short-term becomes long-term, when temporary becomes permanent, something that may not have significantly restricted or substantially limited may turn the corner and change that. If you have a mild to moderate case of COVID, how significantly limited are you in your breathing? If you have a cough for 2 weeks, are you significantly restricted in comparison to the general population? Or in other major life activities, if you have to order shipped instead of going to the grocery store, you feel too fatigued or achy to cook and clean for 2 weeks. Is that, are you significantly restricted? And is that for a significantly long enough period of time to be considered a disability? Probably not in that case. If you are relying on oxygen or mechanical support, a ventilator to breathe, if you need dialysis because you have had organ damage, if you continue to experience periods of fatigue after recovering from COVID, that during these periods of fatigue you are unable to perform any type of activity, then compared to the general population, yes, you are substantially limited, and COVID has become a disability in that case. But generally, what we think of a mild to moderate case, I'm home on the couch, I'm ordering my groceries to be delivered, I'm coughing, I can't smell something, that generally would be too temporary to be considered a disability. High risk of contracting COVID or having complications of COVID. So normally the following conditions would not be considered disabilities solely on their own. They do not meet the definition under the ADA and would not be considered a disability. Those things are being older than 65. Being older than 65 does not limit many people just solely on the basis, or anybody solely on the basis of age. Some people over 65 have other medical conditions, but it's not solely based on age. Obesity is not a disability under the ADA absent any other medical condition that may result from the obesity, but just being obese is not a disability. Being a smoker is not a disability. Obviously, if you have lung cancer or COPD, that is a disability, but the fact that you are a smoker is not. Pregnancy without complications is also not a disability. So these things normally would not fall under the ADA. However, the EEOC has said that with respect to COVID, workers with any of these factors are entitled to reasonable accommodations in this case. So the EEOC has expanded the right to accommodation to people who normally wouldn't be considered substantially limited in a major life activity, to anyone who has been identified by the CDC or a public health organization as more likely to contract or experience complications from COVID. If an employee who is a smoker asks you for a reasonable accommodation because they are high risk due to smoking, and their only high risk factor is that they smoke, the EEOC says you still have to go through the interactive process with the employee. You still have to provide a reasonable accommodation, even though normally being a smoker would not be a disability. So you may think this person is choosing to smoke. They have created the high risk condition themselves. I don't need to accommodate this person. The EEOC has said that you do. Complications from COVID could easily and quickly meet the definition of disability. And I think the idea behind this is why make these people wait and risk death and consume our already stretched thin health resources. And I think we're seeing that now with the shortage of beds and shortage of healthcare workers due to COVID. The EEOC is saying let's accommodate these people with these factors before they end up getting COVID or getting complications and putting a strain on the healthcare system. Generally, when you do have someone high risk, you have an underlying disability already. Someone asking you for accommodations could be someone with asthma, someone with HIV, someone who uses an immunosuppressing medication. But the bottom line is to anyone with any high risk factors, whether they are not normally considered disabilities or whether they are normally considered disabilities, any high risk factors, you do have to go through the interactive process, and these people are entitled to reasonable accommodations. So you do have to make reasonable accommodations for workers with any high risk factors, whether you consider them disabilities under normal circumstances or not. So we talk a lot about medical examinations and disability related inquiries. And this starts all the way back in, when we started at the beginning of the pandemic, having people call in sick, and we wanted to know, can we ask, do you have a runny nose? Do you have a cough? Do you have a fever? All the way up until now, asking people, are you vaccinated? Can you provide proof of vaccination? We've been looking at medical examinations and disability related inquiries, and how does the ADA regulate these things? What is the law behind this? So this is where we're getting to the root of all the questions we've been asking during the pandemic that normally would have raised huge red flags, and we would have said, turn back. But now with some of these things, we are saying, push forward. Normally, an employer cannot perform a medical examination, any procedure or test that seeks information about an individual's health. Weighing somebody, taking their blood pressure, taking their temperature, having them jump rope, for 60 seconds and measuring their heart rate. If you're trying to see whether or not they can perform the job, if you're saying your job involves lifting these 30-pound boxes and putting them on this high shelf, seeing if they can do that is not a medical examination. But if you're looking for information about their health. That would be a disability related inquiry, would be any question that you ask where it is likely that the answer will contain information about a disability. So when is this permitted? Generally, these are permitted post-offer, but pre-employment. So you can, many of you may have the questionnaires that you give out with an offer of employment that asks a number of medical questions, and you know that you can give those out at that time. But once they have accepted the offer and employment has begun, the window is closed and you no longer can ask those questions unless the examination or the inquiry is job related and consistent with business necessity. Well, when is something job related and consistent with business necessity? When the employer believes the employee's ability to perform the essential functions of the job is impaired. If you've got someone who their performance has dropped to the floor and you have heard from other employees that they are receiving cancer treatment, you believe that they performing their essential functions is impaired. And you believe that that may be related to something medical. So asking that employee, is there something medical that is affecting your ability to perform your essential functions? That would be where it would be permitted. Or you can do these things when the employee will pose a direct threat due to a medical condition. So mostly we're getting to job related and consistent necessity on the direct threat bus. There's no doubt that COVID is a direct threat. It's highly contagious. It can be fatal. It's airborne. Masks and vaccines can stop the spread. Science has proven that. Some people are at higher risk to contract or experience complications of COVID. Certain symptoms may indicate that someone may be positive for COVID. We want to prevent exposure by keeping people who are positive for COVID out of the workplace. All of these things we know, and all of these things have led us to believe that yes, COVID is a direct threat. It is a medical condition, and so stopping the spread of COVID, keeping people safe, this is job related and consistent with business necessity. Generally, we're not allowing disability-related inquiries with the questions. We are allowing questions like, do you have symptoms? Have you been vaccinated? Those questions are not likely to reveal the existence of a disability. If you ask someone before they come to work, do you have a fever today? It is not likely that they are going to say, you know, actually, I have a fever and I also have diabetes. If you ask someone, have you been vaccinated? That requires a yes or no answer, and without any pushing from you or any suggestive follow-up questions, it is not likely to elicit information about a disability. You need to know when to stop. If someone says they are not vaccinated, you should not ask why not or when are you getting vaccinated. So you do, while yes or no is not a disability related inquiry, you do need to know where to stop on that. Taking temperatures, requiring negative COVID tests. A COVID test would be a medical examination. Requiring negative COVID tests to return to work. Testing as a reasonable accommodation or as mandatory if someone can't or won't be vaccinated. Those temperature screenings and COVID tests are preventing a direct threat to your workforce. So they are job related and consistent with business necessity, and those medical examinations are allowed. Interestingly, the CDC has never stopped recommending temperature checks and self screenings before coming to work. So they have never stopped saying, ask your employees to take their temperature and ask themselves if they have any of these symptoms before they come to work. That's kind of fallen by the wayside. We've kind of stopped doing that since the early pandemic. If you want to do that, again, that's allowed under preventing a direct threat. If you keep any questionnaires or if you make a record of people's temperature, of course, that's confidential medical information, and the ADA regulates what you have to do with that confidential medical information. You can't just stick it into a file cabinet. High-risk employees, you cannot put an employee on leave or terminate that employee just because they are on the CDC's list of conditions. If you have an employee who has asthma, you cannot say you are on the high risk list, you're gone or you're on leave. You must use an individualized medical assessment for all high risk employees. You need individual medical information as to how their condition affects their risk. Asthma may affect people in different ways. What you have to evaluate what the consequences may be, what could reduce their particular risk. Are they more likely to contract COVID, or are they more likely to have complications from COVID? Go through every possible accommodation that might eliminate or reduce the threat. And you can only really have somebody go on leave or remove them if there is a direct threat that can't be mitigated by a change or any accommodation you can make. The way you should be looking at this is not what can we do to this employee, but what can we do to make our workplace safer for all employees, including the high-risk employee, unless there's a high risk to the employee's safety just by physically being in the environment, and there's nothing you can do to make it safer. Putting the employee on leave at that point may make sense if there's just absolutely nothing you can do with the employer with respect to their condition. So accommodating high-risk employees, we've talked about these throughout the pandemic: masks, moving their work area, socially distancing, working from home. Job assignment, reassignment, and leave, these should be your last resorts. These should not be your first go-tos on the list. Reassigning someone to a different job, maybe so that they can sit somewhere else or that they can work, reassigning them to a job where work from home is possible, reassigning them to a job where they are in an isolated area of the building, anything like that. Reassignment of a job is generally the accommodation of last resort, but because we have no idea when it will be truly safe for everyone to come back to work, and there will be no outsized risk to anyone. We have no idea who will ultimately be required to vaccinate and who will receive an accommodation and what the accommodation will be and whether people will have a choice. We just don't know right now what the future holds, what the transmission rates are going to look like as more governments and employers are mandating vaccination. Leave could be so indefinite under these circumstances that an employee may prefer getting a different job that lets them work from home or in an isolated area rather than sitting at home on leave, not getting paid and not getting benefits. So how much leave is reasonable? Indefinite leave with no projected return to work date is not a reasonable accommodation. If someone says, I need leave, I have no idea how much I need, I have no idea when I can come back to work, there is no measurable metric or goal that I have to meet that will let me know I can come back to work, that's not a reasonable accommodation. However, since the beginning of this, we've all been optimistic and we have been projecting a time when we can return to work. 12 weeks is usually considered the default reasonable for everyone, because if you were subject to FMLA, you would have to do it and you would have no other option. So even if you're not subject to FMLA, 12 weeks could still be reasonable ADA leave. A court has found 7 months of ADA leave reasonable. In that case, the employee was going through procedures that were restoring his health and leading him on the path back to work. Things are constantly changing with COVID. Give your employees a reasonable amount of leave. Give them a shot at things changing, transmission rates dropping, vaccines changing things, masks being more effective. Just, I would say, employees on leave, if you have to put them on leave, just give them a chance. Don't say 2 weeks and you're done. If you sent, so an accommodation for COVID does not make it an accommodation forever. If you sent employees to work from home and are now bringing them back due to the vaccine, and you have an employee who is sent to work from home but is now vaccinated and is not considered high risk anymore, that is not always the case. They can be vaccinated and still be high risk. They don't have a pass to work from home forever. If you did work from home and you had to take away essential functions of the job to make it work because you had no other choice to keep your business running during COVID, this does not necessarily open the gates to work from home as a reasonable accommodation forever. Reasonable accommodation does not mean you have to take away essential functions of the job. So if essential functions of the job means meeting with clients in person and you suspended that to allow people to work from home, that doesn't mean you have to suspend that essential function forever. If people are coming back to work, you can say, this is an essential function and we're not going to remove this to make an accommodation. Proceed with extreme caution on this and get legal counsel before you do this. But don't worry that a work from home accommodation in an extreme circumstance is going to change the game forever for you. OSHA guidance. So the ADA requires you to provide a reasonable accommodation to your high-risk employees. OSHA goes even further and requires you to take all necessary precautions to ensure the safety of your most vulnerable employee on your workforce. So if you've got unvaccinated employees going maskless, don't just tell a high-risk employee, you can mask, that's your accommodation. If you don't like it, leave. OSHA is saying you've got to do everything you can to make that high-risk employee safe, which means if you've got unvaccinated employees going maskless and you've got a high-risk employee, I'm sorry, you have to put masks back on all of those vaccinated employees because you have to be doing everything you can to keep that employee safe. So even if they're vaccinated, if you've got a high-risk employee, put masks back on your vaccinated employees. Or consider it. Consider a mandatory vaccination policy. If you're not subject to the rule, obviously this is all going to change over sending a couple of high-risk employees on leave. That this is not the black letter law, no exceptions. I'm not suggesting you're doing something illegal if you don't implement a mandatory vaccine policy to protect 1 or 2 high-risk employees if you're not subject to the mandate. But based on OSHA guidance, that's kind of the direction that they're heading. OSHA strongly supports vaccination. You could think about if you have high-risk employees and OSHA requiring you to protect your most vulnerable employee. Think modifying the work environment, not just making a change for the high-risk employee, but making your whole work environment safer. You could install plexiglass barriers, you could improve your ventilation or filtration system. It's true that you do have to make an accommodation for an employee with a disability. You don't have to make their preferred accommodation or their first choice accommodation. But when you're doing this, I would think about not just the one employee and their right to an accommodation, but I would think about employee morale and the optics of what you're doing, who you're protecting, what you're doing to make sure all employees are protected, and think of the optics both publicly as a company and if someone made a complaint to a regulatory agency, does it look like you're trying to protect your employees or does it look like you're trying to push out anybody who you would potentially have to accommodate. Just think about how it's going to look when you decide how you're going to accommodate or modify your workplace. Side note on FMLA, FMLA and ADA are two completely different laws with two completely different rights and responsibilities and two completely different eligibility requirements. However, when we are talking about leave as a reasonable accommodation under the ADA, FMLA questions always come up. So here's a side note about FMLA. These are questions I get. Can you get FMLA if you have COVID? What if your parent, spouse, or child has COVID? What if you're quarantining? And if you have a condition that makes you high risk, such as asthma or COPD or something like that, can you get FMLA to stay home and avoid catching COVID? So eligible employees can take FMLA for their own serious illness or to care for a family member with a serious illness. Uncomplicated COVID. I felt sick. I went to the doctor or urgent care or CVS and got a test. I stayed home and rested and drank fluids. In 10 days, I felt better. That does not qualify as a serious illness, whether it's you, your parent, your spouse, your child. Serious illness definition is usually overnight stay in a hospital, something that incapacitates you for more than 3 consecutive days, and includes ongoing medical treatment. And this is the Department of Labor has kind of opened it up and said, ongoing medical treatment can include video visits as well as in-person visits. But the incapacity for more than 3 consecutive days also requires a single appointment and follow-up care or ongoing medical treatment. So not just 3 days absent, but also some follow-up with a healthcare provider. Or a serious illness is also a chronic condition that causes flare-ups where the employee or their family member is incapacitated and requires treatment by a healthcare provider at least twice a year. So usually with uncomplicated COVID, you can meet the incapacitated for 3 days and a single appointment, but there is generally no follow-up care. The doctor says drink fluids and rest and get better. COVID that puts you in the hospital overnight or requires an ER visit and then follow-up visits to a doctor several times after that are going to qualify for FMLA. Long COVID is going to qualify if the employee or the family member is followed by a doctor. If someone has a mild case and they drink fluids and they recover and they don't see a doctor and they come in and they announce, I have long COVID because they continue to feel tired, that is not enough. They do have to have continuing care. You cannot get FMLA to quarantine, even if you were exposed to someone whose COVID would qualify them for FMLA. So if you have a parent, child, or spouse who does have an FMLA qualifying condition and you are not caring for them, you are just quarantining because you have been exposed, you cannot get FMLA for that. You have to be actively caring for the person or you have to be actively sick. If you are high risk, you cannot get FMLA to stay home. You have to be actively sick. If you get COVID and you get complications because you have an underlying condition, then FMLA will come into play, but you can't just get it for avoiding COVID. You have to actually be sick. What if an employee tests positive, goes to the doctor later for chest pain, gets on meds, but refuses to go back to the doctor, but still can't work? Technically, this may not meet the letter of the law. You may or may not be able to get a certification of healthcare provider. It's your call on this point if they're, if they've had one follow-up visit or if they, are getting ongoing treatment or, it's, if you want to split hairs. I would err on the side of being employee friendly. But this is just a side note about the FMLA and not the ADA, but there is some intersection and the question does come up. Asking about illness. Do you have an employee who says, That violates HIPAA when you ask them why they are sick when they call in sick. It does not violate HIPAA for you to ask an employee why they are sick. It is perfectly fine for you to ask an employee what's wrong when your employee calls and says, I can't come to work, I am sick. You have a right to know. You have a right to know if somebody in your workplace possibly has COVID. And if possible, you need to start the interactive process for accommodating a disability, or the FMLA process if someone is out for an FMLA qualifying reason. So you can ask people why they are sick. You can require your employees to report COVID symptoms if they develop them at any time. You can discipline your employees if they have a COVID symptom and don't report it. Don't ask these questions of employees who telework. If an employee teleworks, they're not going to spread it. If an employee calls in and says, I can't do any telework today, I just have to sleep, I can't do anything on my computer, don't ask them if they have COVID symptoms. It doesn't matter. They're not coming in and they're not going to spread it around. You cannot ask questions about trying to determine about high-risk employees. Don't ask, is there a reason why you may need to be hospitalized, or are you at risk of complications of COVID that may cause you to miss more than 2 weeks of work? You can let employees know that you will take advance requests for accommodations, but you cannot ask people if they will need them if they haven't volunteered. Family members' illness, there is the Genetic Information Non-Discrimination Act, GINA. It is like the ADA for family members. It prohibits you from requesting any medical information about a family member. Where this, I often see this come into play, someone calls and says, I'm taking care of my mom, she has COVID, or I have to stay home in quarantine, my child has COVID. You cannot ask for the family members' test results. Do not ask to see the family members' test results. This violates GINA, which is a federal law just like the ADA, and is going to get you in trouble. And there's no interactive process for family members if a family member is disabled. You shouldn't ask anything about whether a family member is high risk or has complications. If you're asking about exposure, if you want to know if this person has been, if your employee has been exposed, use the phrase household member instead of family member, because you should not be asking about a family member's illness. So if you want to ask, do you live with someone who has tested positive, say household member, don't say spouse, child, parent, family member, stick with household member. Notifying others, do not tell anyone, coworkers, about a specific employee's exposure. You want to notify people on a need-to-know basis. Managers may have a need to reorganize workflow, but if someone does not have a business need to know that, do not disclose the name or identity. Use something to tell employees like someone who works on the 4th floor has tested positive, someone who works in the punch press department has tested positive. You can tell if there are close contacts that need to test or isolated, that someone they have a close contact with is positive. They may figure it out, but no one who does not have a business need to know should know the name or identity. You may tell, if you have an employee who tests positive, you may tell your clients, customers, or contractors, if you are a staffing agency or supply subcontractors, you may tell them the name of an employee who has tested positive if your employee has worked on site. I'm sure right now you're asking, did I do my research this morning, or was I just playing around on the internet? I thought we were never allowed to give any confidential information about an employee to our clients, customers, contractors. I'm giving you your one exception. Please don't ask me about giving out any other confidential information. This is your one exception where we will tell you you can do it. If you have an employee who has tested positive, and works on site at a client or customer's site, you do have to know them so that that organization, your client, can contact trace, so that they can trace your employees' movements through their site and trace their contacts and notify people in the area where your employee has worked that they have been exposed. So one exception to give the name, and that is if you have an employee who has tested positive, you can tell the owner of the site where they are working. Requiring test results, a COVID test is a medical examination, but there is business necessity in notifying employee status. Antibody testing is not permitted by the ADA. Results are confidential medical information. They must be stored in a secure location, separate from the personnel file. If you are doing testing, regular testing as an alternative to vaccination, every single test result must go into that confidential file. I recommend having an online file, not having paper lying around, uploading this to a secure encrypted file that no one can access to keep this from being disclosed. And if they're bringing in their results on paper, securely shredding or destroying them. But you, if you are keeping test results, those are confidential and you have to safeguard them. Requiring a positive test for PTO if someone says, I want to use my sick leave, and this is not, and you're not in a paid sick leave jurisdiction, saying you have to show us a positive test to get sick leave. That's okay. It's not, it doesn't make a lot of sense. Anyone who has symptoms or exposure should be allowed to go home to stop the spread. Letting people voluntarily choose whether they want to test or get vaccinated does not elicit disability related info, so that's fine. Do we have to pay for the testing? What if we require them to come back to work to have a test? What if we have a mandatory vaccine policy and we allow testing as a reasonable accommodation? What if it's our only reasonable accommodation? What if we're subject to the OSHA rule and they let anybody choose testing instead of vaccination? I don't know the answer to that yet. If an employer chooses the facility for a medical examination, the employer definitely pays. Think about how you pay for drug tests. You're paying for drug tests because you're telling the employee where to go to have the test, and you are paying them for their time spent testing. If some states require employers to pay for any test required by an employer, background checks, getting your fingerprints, etc. Time spent testing at the employer's direction is usually compensable time. OSHA and the OSHA rule and DOL guidance is very likely going to clarify who is paying for testing of employers who are subject to this rule, and either choose testing or get testing as a reasonable accommodation. And once we get that guidance from the Department of Labor, it's going to make sense for other employers to follow this subject to state law. Some states may say that employers have to pay every time, no matter what. I would check with counsel to find out your state law, but right now there is it's not completely settled who has to pay for it. Pre-employment questions about vaccination. Can you ask on the application? Can you ask during the interview? Can you ask pre-offer? Can you ask post-offer? You do not want to ask a question that will elicit information about a disability. If you put, are you vaccinated, with no other information on your application, you may get people giving you an explanation or just figuring you won't hire someone who can't get vaccinated, and they may have a medical reason and they may think you're shutting them out. The best thing to do is to state clearly on your application, as a condition of hire, we require you to be fully vaccinated for COVID-19 or eligible for a reasonable accommodation to vaccination for medical or religious reasons. We have a mandatory vaccination policy, but we provide reasonable accommodations to individuals who are unable to be vaccinated for religious or medical reasons. If you put that on your application, people who do not want to get vaccinated for personal or philosophical reasons are usually going to throw your application in the trash. They don't want to work for you. So you've got people self-selecting out of the process if you put that clearly on the application. To be really safe, you can say, please do not provide any religious or medical information on this application. In the interview, your interviewers have to be super skilled to ask this question, and even so, disability-related information may slip out. Your interviewer can say, if you are hired, we will require you to provide proof of vaccination or document the need for a reasonable accommodation. Without providing us with any medical or religious information at this time, can you affirm that you are able to do one of those two things? Do not provide us with any medical or religious information at this time. If your interviewers can make that perfectly clear and just get a yes, I can do that, or no, I can't do that, then asking during the interview is permissible, but you have to be, interviewees are really, really, really gonna wanna tell you if they can't get vaccinated for medical reasons. And so you have to be very sure that you can prevent them from sharing that information with you at that time, because they're really going to want to tell you about it. Post offer, ask away, ask when were you vaccinated, when will you be vaccinated, here's how you request a reasonable accommodation, this is the medical information that we need. Again, it goes into the confidential medical file, but post offer, not a problem. Asking for proof of vaccination, I stress, and I stress this in our webinar on vaccines, brand name and date of shot only. People who get shots in doctor's office may get a visit summary with their weight, temperature, blood pressure. Some people who use the app or vaccination sites may get a printout of their entire vaccination history. The ADA prohibits you from having this information. All the ADA allows you to have is the brand name of the shot and the date. Make it absolutely clear to anyone you're asking for proof of vaccination that they make sure there is no extraneous medical information on what they are giving you. So much as a yes or a no is confidential medical information and must be safeguarded as carefully as you would safeguard a doctor's note. Again, I advise a separate file for every employee that's encrypted in your computer system, and paper copies of proof are trouble. You don't need, do not have paper copies lying around. Have everything securely encrypted online or uploaded to the cloud, and do not even bother with paper copies. If people bring them in, shred them or destroy them. Vaccination status and third parties. Vaccinations, your client, customers, contractors may demand that everyone you send to the job could be vaccinated. You cannot just say okay and send over a group of vaccinated employees. Vaccination status is still confidential medical information under the ADA, whether it is a yes or a no. Employees may self-disclose, but you cannot. Your third party must accept employees who are getting a reasonable accommodation. If your client, customer, contractor says, no, we want vaccinated only, you can ask them why. If they try to claim that it's an undue hardship to give accommodations, ask them for an undue hardship analysis, which is a detailed written analysis explaining just how allowing a reasonable accommodation will impose a significant difficulty or expense on their business. Ask to see this. Tell them that you want to see a written out analysis that explains exactly why they can't provide reasonable accommodations. If they tell you it's just inconvenient or they can't provide you with any type of analysis, tell them no, it is breaking the law if they don't allow reasonable accommodations. They're doing something illegal, and you probably don't want to do business with them. Tell your employees a requirement for the job is disclosing either your vaccine status or your reasonable accommodation status to the third party, and they must meet that condition to work the job. For those who volunteer, get a consent form saying they're voluntarily disclosing their vaccination or reasonable accommodation status to the third party, and they're consenting to you being the middleman or the messenger and delivering that information. Tell the third party you will attest that everyone you are sending is either vaccinated or has documented a need for reasonable accommodation. Sending individual proof for everyone is a bad idea, and you should push back. Your responsibility under the ADA is to safeguard that confidential medical information. If that proof gets out, if they don't safeguard it, you're left holding the bag if there's an invasion of privacy claim. The third party may figure it out who is getting a reasonable accommodation. If the reasonable accommodation is masking or social distancing, if the reasonable accommodation is regular testing, you should attest to the whole group. Everybody meets your requirements and not identify who in the group is vaccinated and who is getting regular testing. Regardless of whether the reasonable accommodation is visible or invisible, do not disclose the reason for reasonable accommodation. Absolutely do not let your clients, customers, or contractors request the proof of reasonable accommodation, the documentation of the medical condition, and re-litigate the decision of whether the employee really needs it. They are your employee. You are responsible for the interactive process. You are responsible for safeguarding the confidential medical information. They don't get to remake that decision as to whether your employee needs a reasonable accommodation. Do not give them the documentation that the employee has submitted. If the third party is a geriatric cancer operating room, you can tell your employee that there is no way to mitigate or eliminate the direct threat in the assignment. You know, that's one of the few examples of reasonable accommodation I can, or undue hardship I can think of. But this should all stay between you and your employees. The only thing that should be exchanged between you and the third party is the attestation that the employees meet the requirements. And just summing up here, we just have a couple minutes. Disabilities and masks. The ADA still applies in jurisdictions with mask mandates. It applies to your business if you mandate masks. No matter where you are, you have to make a reasonable accommodation for an employee or patron, client, customer, vendor, anyone on the property. If a disability prevents them from wearing a mask, again, you do not have to provide the preferred or first choice accommodation as long as you provide an accommodation. People don't, you know, if someone tells you they're going to call their attorney, they're going to sue you, they're going to make a complaint to the Department of Human Rights because they don't like the accommodation that you're offering and they want something else. Don't worry about it. As long as you are offering something that is reasonable, it does not have to be the thing that they want. You can go through the interactive process and ask for medical documentation from employees who tell you that they have a medical condition that prevents mask wearing. Don't ask other people, clients, vendors, customers who come on the property for proof. If you can provide an accommodation, do it. If you can't provide an accommodation without undue hardship, again, write up that undue hardship analysis explaining that if your accommodation for an employee who can't wear a mask is regular testing, your accommodation for a customer or a vendor could be you have to produce a negative COVID test if you need to be on the property. That is an accommodation. If they can do contactless, where a vendor leaves the packages outside and a masked employee comes out, or you have a vaccinated, masked, non-high risk employee who feels comfortable providing a service to an unmasked customer in a safer location or outside of business hours. that's fine. If you can't do any of these things, you do not have to let someone on the property unmask. Remember, OSHA requires you to protect your most vulnerable employees. So if you have someone working inside who is high risk and can't wear a mask, an unmasked person coming inside, coming in from outside is a risk to them that you need to protect them from. So think about that. Think about protecting that high risk employee that you have, and consider that in your undue hardship when you're considering what your reasonable accommodation is going to be. If you have a mask mandate and you have an employee who can't mask or wear a face shield or work from home or socially distance, consider having a mandatory vaccination policy to reduce the risk. All mask mandates have exceptions for disabilities, so you wouldn't be violating a mask mandate to let a high-risk employee go without a mask. If you vaccinate everybody else, your other employees may feel more protected. Again, it's, OSHA would definitely support something like that. Whether your employees would like it or not is obviously another story. So if you have questions, or I don't know if we, looks like I've gone 1 minute over, and I don't know if we have any questions, or
Hi, Britt. We don't have any questions at this
okay.
time. So if you have any questions, feel free to answer them in the chat box on the control panel. Otherwise, feel free to reach out to us at info@myhrcouncil.com, and we'd be happy to answer those questions for you. And then if you're a client of ours, we can provide you that legally backed answer through our Ask an Attorney portal. We have one question here. Is there a SHRM code? No, we are only offering HRCI credit at this time.
Well, again, I know I talk fast and I just bombarded you with a lot of information there. So if you do have questions, or if you receive the slide deck and the recording, and you think there are things you need more information about, like Dan said, please email info@myhrcouncil.com, or use the Ask an Attorney portal if you are one of our clients. And if you are not a current client and would like more resources, such as some of the advice that given in this webinar, you can certainly go to myhrcouncil.com and check out some of our packages and our offerings to give on-demand attorney-backed legal advice.
Hi, Brett. We just had a couple questions trickle in here. The first is that if a client refuses to allow reasonable accommodation, what is the form that we should ask for called?
So there's not a form necessarily. There's no government regulated form. If you have a client and they say we want vaccinated only, no reasonable accommodations, say, that's great. What's your reasoning? And if they say we just don't like it, you can say that violates the ADA. If they say, well, it's an undue hardship, we have an exception to the ADA, say that's great. Can you provide me with an undue hardship analysis? And if they say we don't have one, or we don't know what that is, basically tell them, if you think you have an exception to the ADA, if you think you have a reason to deny reasonable accommodations that supersedes the ADA, if you think you have an exception, put it in writing, describe exactly why you think the ADA doesn't apply to your business in this situation, and let me see it. And let me see it so I can take it to my attorney and see what my attorney has to say. Make them, if they think that they don't have to provide reasonable accommodations, just ask them to prove it. Say, explain to me why, and put it in writing, and then certainly bring it to us, because they cannot just say we don't provide reasonable accommodation. And if they think they have an undue hardship exception, then tell them we want to see their explanation as to exactly why they think that exception applies to them.
And then just the final question that we have, I'm not sure if we'll be able to answer this correctly or not, but who pays for the COVID test if an employer makes vaccination optional?
So if an employer makes vaccination optional, and then if vaccination is optional, and then you're requiring COVID testing as well, I guess I'm not.
My assumption is that if it's either you get vaccinated or receive a negative test.
Oh, okay.
I could be wrong, but
So if that is something that I can't really answer right now, because like I said, there are states that say definitely, absolutely, if you're an employer and you're requiring a medical examination, you're requiring a test, you have to pay. Most of the states are not like that, and it's just kind of a gray area right now. Who would have to pay in that situation if you've got a vaccination or regular testing policy. When we get the OSHA rule, we can kind of take what the feds are mandating and extrapolate that to all employers and say, this is what you should be doing as well, or this is kind of the guidance now from the Department of Labor is employers pay for the test, or if employees choose testing, employees pay for the test. It's just a gray area right now, and I don't, other than states where, if you're in California, I would say you absolutely pay for the test. Don't make employees pay for the test in California, where you're asking for trouble. But in other states, I would just say it's a gray area right now, and just really research your options as to, what's our most cost-effective method of getting these employees tested in the event that we do have to pay for it.
all right. I think that's the final question. Thank you so much to everyone who attended. And once again, we will send that email on Thursday, which will have the HRCI code for attending, the slide deck, as well as the recording of the webinar if you had to leave for whatever reason, or if you just wanted to reference it again. And additionally, we will be hosting that webinar once OSHA releases the final rule. Pay close attention to our social media, or if you subscribe to our newsletter, we will include the registration link for that. We look forward to hosting that webinar and having you all attend for that. And thanks again to everyone who attended. We greatly appreciate it. Have a great rest of the day.